Are you dreading the probate process in Washington State? It's a complex journey that can feel overwhelming, with potential pitfalls that could delay your loved one's estate or lead to costly disputes. But don't worry, you don't have to navigate it alone. Join me in this episode of Legacy Talk to uncover the critical steps to manage Washington's probate process effectively, avoid mistakes, and gain the confidence you need to settle an estate properly.
You are listening to the Legacy Talk podcast hosted by James A. Jones,
attorney at law and founder of Sound Legacy Law, PLLC in Tacoma.
Attorney Jones is here to talk about how to best protect your family, assets, and wealth, pulling stories from his more than 20 years of helping families and business owners protect their assets, create their estate plans, preserve their wealth, and plan for the future. Nobody wants to think about estate planning, but life has a way of sneaking up on you, and at any moment, something unexpected could happen that will leave you regretting not having acted sooner. So join Attorney James A. Jones in the Legacy Talk podcast, and together learn how to plan for your future today and have peace of mind tomorrow.
Welcome to Legacy Talk. I am your host, James Jones. On today's episode, we are talking about Probate 101 in Washington State, a step-by-step guide. And I'm doing this episode today because, I have a lot of clients. We do a lot of probates here in Washington. And it's just such a common thing that people worry about that I thought we'd do a 101, like let's go over the basics. Let's talk about this process, and let's talk about what needs to be done so that you don't have any problems, right? There's just so many problems. I get clients all the time where they try to start a probate on their own, and then it turns out that they didn't realize they had to do certain notices, or they had to publish things in the newspaper. They have to go to court potentially, right? And so let's just talk about things simply probate-wise and see where we go. So we'll start with this. What is probate? Like, James, what are you talking about? What is probate? I've heard this word. I know it's a bad thing, or I've heard it's a bad thing. What is it? So probate is basically a court-supervised process in order to administer someone's estate, okay? If there's a will, it validates the will. If there are debts, it helps pay debts. If there are assets, it helps distribute assets. There's almost always assets, okay? And it's not something that's always required, but it is oftentimes it is required, okay? There's lots of cases where probate is required, which we'll talk about later. Washington is not the worst probate state in the world or country. There's many states worse, like California is worse. There's states in the East that are worse, right? Washington has something called a non-intervention probate, which means that once you're appointed by the court, you can handle most things without further oversight of the court. You just have to sort of check in at the end. Okay, so that reduces court time and costs for lawyers. So that's a positive, okay? So let's think about this scenario, okay? If a family has a $200,000 house, that's going to have to go through probate, right? Without a will, or even if there is a will, that's going to have to go through probate. All real estate that's in a deceased person's name has to go through probate. And I'm going to back up here, because probate we talked about is paying debts, dealing with a will, distributing assets. But really, probate is a title clearing process, right? We want to make sure that someone who is deceased, who's died, can't sign their name anymore. And so they have to go to court to be appointed by the court to become something called a personal representative or an executor. And that's probate, right? Getting authority from the court, or having a court give you authority to make decisions and transfers and distributions from someone's estate, okay? So when do we have to do probate? When is probate required in Washington? And so there's certain triggers, okay? Typically, like I briefly mentioned before, if you have real estate and the house is only titled in your name or the deceased person's name, and it doesn't have a joint tenant with right of survivorship designation or transfer on death or anything like that, that real estate has to go through probate, okay? Sometimes personal property that exceeds a certain dollar amount, which is $100,000, and doesn't have beneficiary designations, this is like bank accounts, vehicles. If it's over $100,000, you probably have to go going through probate, okay, unless there's beneficiaries. And then another reason for probate is if there's a lot of heirs that are causing problems, or there's creditors causing problems, and you need the court to sort of step in and kind of give you the authority and give you the, judicial backing power, I guess, to resolve these things, you sometimes want to do a probate in that situation. The exceptions to probate are also available, and there are some. So if the estate is under $100,000, like if you have a bank account and cars that are worth less than $100,000, you can do something called a small estate affidavit, okay? And that has to be after a waiting period. It's a 40-day waiting period. You can do that, okay, if you're under $100,000. Things that have beneficiary designations like a 401k, a life insurance, bank accounts, things that have beneficiary designations don't go through probate. Or real estate that's held joint tenant with right of survivorship, that doesn't have to go through probate. And also, if you have something called a revocable living trust, that asset doesn't have to go through probate. So if you have your assets in trust or revocable trust, or any kind of trust really, that asset doesn't have to go through probate because the trust provides the authority to the executor or trustee of that trust, okay, without getting it from the court. In Washington, also, you can have something called a community property agreement, which works for married couples only or domestic partnerships. But those agreements basically say when one of the spouses die, the assets that are community are immediately vested in the name of the surviving spouse, so they don't have to go through that court process. Okay? So here's a scenario. A single parent leaves $50,000 with a payable on death designation and a $150,000 house in their name only. Okay? So what happens? The bank account with the payable on death designation avoids probate. But the house, because that's in the name of the parent only, has to go through probate. Okay? So what you want to do on your own side, right? This is if you're thinking about doing your estate plan, you want to review your titles to your assets and how you have beneficiary designations. I'm not saying you want to do all your real estate with joint tenant with right of survivorship. I would not say that, because there's other reasons, and I've had other episodes about this where we don't want to necessarily name our kid the beneficiary or name our kid on the house with us, because that causes other problems. There's other episodes about that on this podcast. So there's other avoiding probate episodes, so check one of those ones out. I can't tell you exactly what they are right now, but if you look on my podcast, you'll see the other episodes. So you don't always want to put your kid on their house, okay? So, but if you do want to do designations of beneficiaries or do payable on death or transfer on death, designations of bank accounts and investment accounts, those are pretty easy to do, okay? So, James, what is the process for probate? What is the process? Like, if you wanted to try to do this yourself, you could, potentially. There's a certain situations you can without a lawyer. One of which is you have a will and you're named in the will as the executor. The other of which is you're the surviving spouse. Other than that, it's difficult and almost impossible to do a probate without an attorney. If there is a will, okay, we'll say that you're not going to do a probate without a will by yourself, okay? Let's just say that's how we're going to do this. If there is a will, the first step is you file the will with the court, okay? If you're the executor named in the will to manage the estate, you file the will, okay? And you petition the court, you file a petition to get appointed by the court, okay? That petition requests that the court appoint you as personal representative and get something called letters testamentary. Those are letters that you get when there is a will. They're called letters of administration if there's no will, okay? And those letters give you as a personal representative authority to act, okay? To deal with the estate, whatever needs to be done, under the will or asset-wise, you can do it with those letters. They're your magical letters, I say. And in most cases, you get something called non-intervention powers. And those non-intervention powers allow you to be independent from the court for most things, right? They allow you to sell the house. They allow you to deal with the bank, distribute assets, pay bills, all that stuff, right? Most cases are non-intervention cases in Washington. Sometimes it's very rare. Like, I've been doing this 23 years, I think. And I've had one or two maybe that didn't get non-intervention powers right away. I just had one recently, actually, which was really weird. The commissioner appointed my client, commissioner's like a judge. They appointed my client as executor, but they didn't give him non-intervention powers. They made it with full intervention because there was a question as to, there wasn't a will for one, and there was a question as to whether there were other heirs that should be given notice on this, which there weren't. And so we had to revise that motion. We had to basically have that order changed through appeal, basically. And we finally got him his non-intervention powers, but it was weird. It was weird. Anyway, so that does happen sometimes. Very rarely, but it does happen. Step 3 in this probate process is to notify the heirs of the estate. That's the beneficiaries. That's, natural beneficiaries typically. And creditors. The personal representative must notify these heirs and beneficiaries within a certain period of time. And creditors typically have notice published in the newspaper and often can receive direct notice. If you know who these creditors are, you should give them direct notice. Okay. Creditors have 4 months to file claims if notified. Okay. Whether it's through publication or direct notice. If you don't notify them, then they have to wait. They have 2 years to make their claim. So you want to notify creditors. Okay. Step 4 is to inventory the estate. The personal representative inventories assets and pays debts. These are like medical bills, taxes, credit cards. Sometimes you have to file a tax return. Sometimes you have to do an estate tax return. There's no such thing as an inheritance tax in Washington, but there is an estate tax, which has a very low threshold, which we've talked about a million times on this podcast. It's about $2.1 million. Okay. There's also a federal estate tax, which is about $14 million exemption. So that one we're not worried about very much. The state one, though, we're worried. $2.1 million is not that much money. Okay. Next step would be to distribute the assets and close the estate. This is something that people that hire me that may have tried to open an estate on their own get stuck, right? It's paying bills, it's distributing assets, and it's closing the estate. After the debts are paid, you're typically supposed to distribute your assets, right? According to what the will says or what the law says. And there's certain paperwork you have to file. And if you file it correctly and give notice correctly, then the estate will close within a certain period of time if there's no objections, right? And so there's a little bit of nuance to that. And I get a lot of people to say, well, I thought I did everything, but I didn't transfer the house, or I didn't file the final documents, the declaration of completion or something like that. And so they come to me and they look for our help, my firm's help. Okay. So the thing that I think makes sense there is, you just want to make sure there's the other thing that we don't have in this list is you probably want to do an accounting if there's multiple heirs and say how much money came in, how much money went out, right? How much money each person is going to get. You probably want to have that out so people can know what they're getting, and you don't have to worry about them saying, well, did I really get everything? You don't want them to worry about that. Okay. So here's a scenario. A couple's estate includes a home, a house, and $80,000 in savings. Okay. They're a married couple. The community property agreement transfers the house to the surviving spouse with no probate. But in this scenario, if the account is not in the surviving spouse's name, they could try using the community property agreement, but that may or may not work at the bank you go to. But they might need to do something called a small estate affidavit, which we mentioned before. So something like that, you wouldn't need to necessarily hire an attorney for. Anything over $100,000, or if there's real estate, you probably want to get an attorney to help you. It's just easier. It's just easier. We go to law school for your benefit, so you don't have to, right? We don't do this all the time, all day, and so it's much easier. So here's some questions. I thought, let's do some questions. These are common questions. Question number 1. If I have a will, I don't have to go through probate, right? Wrong. A will does not avoid probate. A will does not avoid probate, okay? I was just talking to my office manager, who's my probate department leader, and she's like, you gotta ask this question. A will does not avoid probate, right? A will is the entry point to probate, right? The reason a will doesn't avoid probate is because the will just nominates an executor. The will says, hey, I want my cousin Bob to be the executor of my estate, but it doesn't give them any authority. It says, if you want to use this thing, you got to go to court, okay, to get authorized by the judge, okay? That's probate. If you don't have a will, to piggyback on that, if you don't have a will, do you need to go through probate? Maybe not, right? It all comes down to what kind of assets you had. If you don't have a will and you have an estate less than $100,000, the answer is no, you don't have to go through probate. But if you have an estate under $100,000 but a house as well, in addition to your other less than $100,000 of assets, you do have to go through probate, okay? All right. Can I handle probate myself in Washington, or do I need an attorney? Do-it-yourself probate in Washington is feasible. Like we said, you could do a small estate affidavit that's so much easier, but if you have to go through real probate, it's so much better to use an attorney. And if you are not the surviving spouse, and if you're not the executor named in a will, you're not going to be able to open it yourself. You're going to have an attorney to help you. Okay. What happens if I miss the 40-day deadline to file a will? Everybody somehow hears about, I've got to have the will filed with the court within 40 days. That is a statute. There is a statute that says you've got to file this will within 40 days. If you miss that deadline, what happens? The answer to that is nothing. The problem is, if you don't file the will in 40 days or file for the probate in 40 days, then anybody can file the probate. So if there's a will and you sit on it for 2 months or 41 days, and there's a creditor out there that says, this estate owes me lots of money, I want to get that money, they could open a probate. Or if it's a, brother of an estate of a decedent, right? And this says the spouse doesn't want to file the will or waits, that brother can say, well, I'm going to do it. They're not doing it, right? I actually just had a case where a client of mine we've been working with for several years with his mother, and his mother recently passed away, but his mother's brother filed a probate with an old will that is, no longer valid. It was revoked by a subsequent will. But anybody can file a will or a probate after 40 days. So you want to do that, okay? How do you use a small estate affidavit, okay? How can I use a small estate affidavit and avoid probate? I've already mentioned you have to be under $100,000 in cumulative assets value, okay? And you have to wait 40 days for it to be effective. So if you are a legal successor, which means you're like their kid, right? Or there's a will that says you're the executor or you're the beneficiary, then you could use a small estate affidavit for an estate under $100,000. If you are not one of those people and you're just some friend, that's not going to work. That's not going to work for you. You'd have to open probate, okay? Can a community property agreement help if I'm not married? No. Community property does not exist if you are not married, okay? Not legally. There's certain nuance to that, but simply the answer to that is no. We'll leave it at that, okay? What if my sibling disputes the will during a probate? What happens if someone disputes a will during a probate? Well, one of the problems with probate is that it creates a venue for people to make disputes. It makes an automatic venue for people that are kind of not your friends to file stuff. So there can be disputes, right? If they dispute things and can prove it, then there might be issues, right? It's difficult to prove things that are kind of pie in the sky. Like, my mom didn't want that will to have that, to be that way. They wanted to say this. Or their old will said this one shouldn't be valid. Those things are difficult to prove, very difficult. That doesn't mean they can't happen, okay? So, take that for what you will. So, some key takeaways from today's episode. Washington's probate process is not the worst in the world, right? If you can get non-intervention powers, which in most cases you can use a small estate affidavit, but estate planning can minimize all this stuff. If you do estate beneficiaries, if you do a trust or other designations which distribute assets by operation of law, this is not a how to avoid probate episode. It's like, what do we do in probate episode? But if you wanted my advice, which maybe you do if you're listening to this, I would avoid probate 9 times out of 10, 10 times out of 10 in most cases, if I could. There's very, very limited scenarios where I think a probate is more efficient than using a revocable trust to distribute your assets, okay? A revocable trust gives you full control and gives your successor trustee or executor full control to run your estate without any court intervention. And it's also going to be less likely to be contested. And so if you can stay out of court for almost anything, it's a good idea. Okay. So that's pretty much it for today's episode. Make sure you to follow up next week where we'll have a brand new episode. Topic to be determined. So keep your guesses coming. If you have an interesting topic that you'd want me to talk about, send me an email or put it in the comments and I'll look for it. I'd like to thank you for listening to today's episode of Legacy Talk. If you like today's episode or would like to learn more, please like and subscribe for more great content. I've been your host, James Jones. To your legacy.
Thank you for listening to the Legacy Talk podcast by attorney James A. Jones. If you found today's episode helpful, we ask that you like and follow us on all major platforms so you don't miss out on the latest episode. If you have questions for Attorney Jones, reach out at info@joneslegacylaw.com or visit our website at joneslegacylaw.com. Join us again next week for another episode of the Legacy Talk podcast.